Hello viewers, Attorney Buado here. Welcome to the Criminal Law Jurist. This is Episode 5, Kinds of Penal Law. Crimes in the Philippines are of different kinds. We have offenses and felonies, mala in se and mala prohibita, Dolo and culpa, and penal ordinance. Thorough understanding of these kinds of crimes will help prepare an accused to have a better defense, and the prosecution to have a good strategy to block the defense. Let us compare felonies and offenses. Felonies are acts or omissions punishable under the revised penal code exclusively. Offenses are acts or omissions defined and penalized by special penal laws. They are never called felonies because felonies are punishable under the revised penal code. But sometimes, crimes under the revised penal code can also be called offenses. Now, a single act can be penalized under either the revised penal code or a special law, but not under both, because that would violate the rule against double jeopardy. For example, sexual abuse of a minor can come within the provision of rape under the revised penal code or under Section 5B of Republic Act 7610. When under the RPC, it is malum in se, singular of mala in se. When under the RA 7610, it is malum prohibited. So, let us talk about mala in se and mala prohibita. Mala in se are crimes penalized generally by the revised penal code. Generally because there are crimes mala in se penalized by special law, such as the plunder law. These crimes are inherently evil. Mala prohibita are crimes generally punished by special laws. But there are also crimes under the revised penal code that are mala prohibita, like technical malversation. Mala prohibita crimes are punished because the acts are prohibited. Without the law prohibiting them, they would not be considered a crime. They are penalized because prohibited. Example, drinking alcoholic beverages during election. At any other day, drinking liquor is not a crime, but only in election time or in some other specific time specified by law. So let us compare mala in se and mala prohibita. In mala in se, the moral character of the offender is considered. It is the basis. Therefore, good faith or lack of criminal intent is a defense. Second, modifying circumstances are taken into account in imposing the penalty because the offender's moral trait is the basis. Therefore, if the offender has greater perversity, then his penalty shall be higher. If lesser perversity, then his penalty shall be lower. Participation. In mala in se, the penalty is computed on the basis of whether the offender is a principal, accomplice, or accessory. Fourth, stage of accomplishment. The penalty depends on whether the crime is consummated, frustrated, or attempted. What about mala prohibita? The basis is voluntariness. So good faith or lack of criminal intent is not a defense with certain exceptions. Second, modifying circumstances are not considered because morality of the act is not relevant. What the law intends to discourage is the voluntary commission of the act prohibited. Third, degree of participation. All offenders are considered principals with certain exceptions. Fourth, stage of accomplishment. The offense is punished only when consummated. There is no attempted, frustrated, or stages, only consummated. What are examples? Let us take into example malversation. Malversation is taking by a public official who has custody of government funds for personal use. It is malum in se because it is tantamount to stealing government funds. On the other hand, technical malversation, although punished also under the revised penal code, is malum prohibitum because government funds are used not for personal purpose but for a government use also. However, it is different from what the law or the ordinance purposed it to be used. It is malum prohibitum because the official did not steal the funds but used it for another government purpose. For example, if the law appropriated funds for building classrooms, but the principal instead used it to buy books or teacher's uniform, that is technical malversation. He did not profit from it, but he used it for another purpose, which is prohibited, and therefore malum prohibitum. Now let us go to dolo and culpa. Both dolo and culpa are punished under the revised penal code. The definitions of dolo and culpa are found in Article 3. In simple terms, dolo are intentional felonies, while culpa are crimes without malice or unintentional. Culpa are committed by means of negligence, imprudence, lack of foresight, or lack of skill. Example of dolo: Juan intentionally bumped Pedro with his car to kill him. That is murder. Example of culpa: Juan does not know how to drive, but he drove the family car and bumped and killed Pedro. That is reckless imprudence resulting to homicide. Articles 113 to Article 364 of the revised penal code are intentional felonies. Article 365 is quasi-crime or culpa. Article 365 discusses how certain intentional crimes can be committed by culpa, like arson, homicide, falsification of documents. But there is no intent, only negligence or imprudence. Are there crimes that can be committed without criminal intent? So far, we have discussed two different kinds of crimes which are committed without criminal intent. Mala prohibited, it is a crime because prohibited. If there is no prohibition, there is no crime. And culpa, because it is not intentional but committed because of negligence, imprudence, lack of foresight, lack of skill. Mala prohibita are prohibited acts which are not normally evil, like during liquor ban. Culpable crimes are committed not intentionally but because of negligence. We will have more of this in detail in the episode on Article 3 on how felonies are committed. What about penal ordinance? Ordinarily, penal laws are enacted by Congress. Congress has delegated to local legislative council the enactment of ordinance to punish certain misdemeanors. This delegation of legislative power usually relates to the exercise of police power for the general welfare. Examples are clamping of motor vehicles illegally parked or urinating on sidewalks. So, what is an actual case on conviction or acquittal? That depends on thorough knowledge of the concept of felonies. The case of Ibler. Ibler committed reckless imprudence resulting to homicide, slight physical injuries, and damage to property, which are all culpa. He was convicted first for the case involving slight physical injury, which is punished only by fine, very small amount. The fiscal, after that, filed a case for reckless imprudence resulting in homicide and damage to property, which was dismissed because of double jeopardy, because the single act resulted in 3 different damages, homicide, and slight physical injury. So, if the fiscal knew how culpa works very well, and Dolo, that a single act of culpa which results in different crimes or different mischiefs, it should be filed under one information, not split. And it benefited Ibler. That is why I said, thorough knowledge of the different kinds of crimes will help or prejudice an accused. Next time, we will have a very beautiful episode, Philosophies Underlying the Criminal Law Justice System. Recall that during the martial law era, a drug lord was executed in Luneta, televised. Did that deter the commission of heinous crime? Was the purpose achieved? So the philosophies underlying the determination of criminal liability in the next episode will tell us why, or if it is really effective.